Good day, this is Professor Jacobs. Today I'll be teaching on the general principles of insurance contract law, learning units 3 and 4. This forms the second part of the lecture on learning units 1 to 5. Have another look at what learning units 1 to 5 deal with. In particular, look at learning units 3 and 4. We again reiterate that you should refer to Tutorial Letter 101 on the prescribed study material. You should study from the study guide. You should also have a look at Tutorial Letter 102 and the amendments to the prescribed materials, and also study from the prescribed textbook as well as the prescribed cases and articles. So let's start with Learning Unit 3 on the nature and characteristics of an insurance contract. Study from the study guide as well as the prescribed paragraphs from RECIPROCAL et al. Here, the Oudtshoorn municipality case, the Phillips case and the Lake case are relevant. Note also that these cases may be relevant under other learning units. Look at the cross-references. In one of the earlier learning units, we looked at the economic definition of insurance, but today we are going to look at the legal definition. Insurance exists if all the essentials are present. Essentials are the distinguishing features which makes a contract of insurance. Naturalia are those that are present but may be excluded. And then accidentalia is not included but they may be added. Say for instance, one of the naturalia of an insurance contract is that the principle of subrogation is applicable to indemnity insurance contracts. However, an accidentalia can provide a lot of more detail, say for instance, about how payment should be made. For the essentials of an insurance contract, have a look at Learning Unit 3. You need to distinguish that from the validity requirements, which we'll deal with in Learning Unit 4. The Lake case is particularly relevant. Read that case and also study from RECIPROCAL et al. Look at the criticism of that definition. It's very challenging to find an acceptable definition for insurance law, one that includes all the forms of insurance but also distinguish between insurance and other types of contract. This slide provides you with a summary of the possible essentials of an insurance contract. Note the word possible because they may not all in fact be essentials. To know the essentials of an insurance contract, you will have to proceed and also look at all the cross-references in the learning units that I've provided in brackets. So for now, it's sufficient if you just know the possible essentials. Good faith. Here you should again read the Oudtshoorn municipality case. Second, an insurance contract must provide for the payment of premium. Please note here that it must only provide for the payment. The physical payment itself is not an essential. Then it must provide for the payment of a sum of money or equivalent by the insurer to the insured. Risk, insurable interest, and then it's also an independent and principal contract. Look at all those cross-references and also study them as you proceed. It's important to know that an insurance contract is a reciprocal contract. That means that the parties give performance in exchange for each other. Here the insured undertakes to pay premium, whereas the insurer undertakes to pay money or the equivalent. Study from RECIPROCAL et al. And also cross-reference to Learning Unit 12. An insurance contract is an aleatory contract. The main aim is to transfer risk. The insurer's performance depends on the outcome of an uncertain event. Cross-reference here to Learning Unit 9, but you need to distinguish an insurance contract from a wager. A wager is valid but unenforceable. Here you should read the Phillips case and also study from Reinecke et al. An insurance contract is also an independent contract, but the risk is transferred and the insurer does not have control over it. Distinguish this from the manufacturer's guarantee, where the manufacturer of goods has control. Study the prescribed parts from Reinecke et al. An insurance contract is a principal contract. The insurer's performance depends on the outcome of an uncertain event. But distinguish that from suretyship. Suretyship is dependent on a main contract. Here is a question for you to practice. Explain the similarities and differences between insurance contracts and wagering agreements and contracts of suretyship. You need to study all the prescribed study material, both in the study guide and in your prescribed textbook, as well as the cases and articles, to be able to answer these practice questions. Next, we deal with Learning Unit 4 on the requirements for a valid insurance contract. The slide provides an overview of the parts that you should study from the study guide as well as from Reinecke et al. Again, you should cross-reference back to Learning Unit 3. It's very important in this unit to distinguish between the characteristic features, the essentialia, which we've dealt with under Learning Unit 3, and the requirements for the validity of an insurance contract. That's then also the practice question, which you should set out to do after you've studied Learning Unit 3 and 4. So what is important to remember is, if one of the essentials of an insurance contract is not present, then it's no longer an insurance contract, but it may be another type of valid contract if the validity requirements are met. However, if the validity requirements of a contract are not met, that contract is no longer in existence. It's void. What are these validity requirements? They are consensus, capacity to act, legality, performance must be possible and sustainable, and formalities, if applicable. So, the validity requirements for all contracts are the same, apart from the fact that formalities may differ. As to legality, again see the notes on the repeal of Section 54 of the Short-Term Insurance Act and Section 60 of the Long-Term Insurance Act, referred to Tutorial Letter 102. It's also important that you should understand the definitions of an insurance contract, an insurance policy, and a cover note. An insurance contract is the intangible agreement, where the policy is the reduction into a tangible form. A cover note provides interim insurance cover. Cross-reference to Learning Unit 15 on insurance policies and also on interpretation thereof. Again, we invite you to contact us for inquiries. Mrs. De Gama is the module leader for LML4805. This brings us to the end of our lecture on Learning Units 1 to 5, Part 2. I'd like to again remind you to integrate all study material from the study guide, the textbook, as well as the prescribed materials such as cases and articles, and all tutorial letters. Visit the Moodle site regularly. Look at the activities there in the form of discussion forums. The glossaries would also help you. It contains key terms. Have a regular look at the module site. Look at the notice board and the announcements. That's how we communicate to you. Also, visit the official study material and take note of tutorial letters 301 and 302. It contains important information for all students in the College of Law. Tutorial letter 301 deals with assignments and 302 with style requirements of referencing, formatting, and bibliographies. It's very important that you follow those for purposes of the assignments as well as in the exam. Also keep an eye out for new developments, and particularly you should read tutorial 102 and study that for new developments and how it changed your prescribed study material. Also visit the Moodle site regularly for any announcements and important matters. We wish you well with your studies.